I'm going to talk today about the police caution. Now, the first thing to say is to define what I mean by the police caution, because it can be used in two different senses. In the first sense, it can be used as the form of words that is used at the start of an interview under caution. I have previously produced a video about that. Those words are, you do not have to say anything, but it may harm your defence if you do not mention, when questioned, something that you later rely on in court, and anything that you do say may be given in evidence. Now, those are the forms of words at the start of an interview under caution. But it's not that I want to talk about today. I have previously produced a video about the form of words known as the police caution. The other police caution is what the police can do as an alternative to sending somebody to court. So to explain the background, when the police conduct an investigation, there will be a number of outcomes. First of all, the investigation may drop with no further action, or it may mean that the police charge an individual and either take them to court or bail them to court. Or it may mean that the police conclude the investigation and that subsequently a summons or a requisition is issued in order to get the individual to court. However, an alternative option is the police caution. Now, the police caution has been around for a very long time. It's in fact been around since 1853. But the Ministry of Justice has issued guidance from 2015, and it's that guidance that I'm going to go off today. So the police caution may be available in circumstances where an individual makes a full and frank admission to the offence, usually where the offence is quite minor, provided the individual has no previous antecedents, or if they do, they're from a long time ago, and provided that the individual hasn't previously received a caution in the past 2 years. Now, as you would expect, there are going to be exceptions to all of those rules, but that is the general position. So to go through it, first of all, the individual must have given a full and frank and clear admission of the offence alleged. If they've given that to the police in interview under caution, it will normally be under interview under caution, but it doesn't have to be. But what has to happen is that the admission has to be clear. So if the individual has clearly admitted to the offence, you want to look at the offence. Is it a summary only offence, or is it an either way offence, or is it indictable only? Now, the less serious the offence, the more likely it is that a caution may be available. The Ministry of Justice does provide guidance that for the more serious offences, such as what might be indictable only or either way offences, it may still be possible, but it requires either the consent of the Crown Prosecution Service or the consent of a superintendent or the consent of an inspector. And that guidance is set down in the Ministry of Justice report from 2015. But assuming that the offence is relatively minor, it is possible for a police sergeant not connected to the case to consider administering a caution, or at least offering a caution to the individual. The caution still has to be accepted by the individual. So if the police sergeant is prepared to offer the caution to the individual, that sergeant mustn't be involved in the investigation themselves, but they can offer the caution if the individual has made a full and frank admission. Now, when considering whether or not a caution should be offered, the police will want to know the individual's antecedents. Have they got a criminal record? And if they have, from how long ago is that record? The longer ago the individual has a criminal record, so if an offence has been committed but it was several years ago, the more likely it might be that a caution is offered. Conversely, if an offence is shown from fairly recently, it may be that a caution isn't considered appropriate. And then, of course, it will be necessary to check that the individual hasn't previously been offered a caution. And again, as a general rule, and there are exceptions, but as a general rule, a simple caution will only be offered provided that a simple caution hasn't been offered in the past 2 years. The other point I want to talk about is the Rehabilitation of Offenders Act 1974. and how that relates to cautions. Now, under the Rehabilitation of Offenders Act 1974, and I have previously provided a video about that piece of legislation, a simple caution is immediately spent. And what that means is, if an individual receives a simple caution, they are not obliged to tell a potential employer that they have received that caution, provided, of course, the job they are applying for isn't one of the exceptions. So provided, for example, it doesn't involve working with vulnerable adults or children or teaching or in medicine or something like that. The other point to consider when whether or not a caution is appropriate is that, for example, if it's a sex offence, even if a caution is offered, the individual will still be required to register on the sex offenders register for 2 years. So you need to consider whether a caution would be appropriate, because it will still mean going onto the sex offenders register. And the other point to consider with a caution is that the Rehabilitation of Offenders Act only relates to the law in England and Wales. Now, the point being, if an individual wants to travel abroad, for example, if they want to go to the United States of America, it might be that they would still be required to disclose that caution on their ESTA, on their application to enter the United States. And there will be other countries as well, where an individual will still be required to disclose the caution, even though it comes as immediately expensed within the Rehabilitation of Offenders Act. So to conclude, police caution is available as an alternative to prosecution if certain conditions are met. And those conditions are if the individual makes a full and frank admission to the police, if the offence is relatively minor, but check the guidance from the Ministry of Justice 2015 edition regarding that, provided the individual has not got much by way of antecedent history, provided they haven't had a caution in the past 2 years. Of course, the other point to say is that the individual is only offered the caution. They're not obliged to accept the caution. They don't have to accept the caution. They can, if they wish, take the matter to court and possibly try and argue at court that they're not guilty of the alleged offence. However, bear in mind the first part of the requirement for the caution, which is that there has to be a full and frank admission. So if the individual has given a full and frank admission to the police, it may be, each case is unique, but it may be that the police or the Crown Prosecution Service would then be able to present evidence of that admission to the court. So generally speaking, it may be that if a caution is available, if it's possible to receive a caution, if a full and frank admission has been made, it may be that an individual may feel that that is the best way forward. The final thing I want to talk about is the procedure in the event that an individual has been interviewed by the police and has then either been charged to court or given a requisition to court or is some other way about to go into the court system. It may be at that stage that the individual considers whether or not it would have been appropriate to accept a caution. There doesn't seem to be any hard and fast rule on this, but from experience, the best procedure to follow may be to contact the court, to contact the Crown Prosecution Service, and to contact the police, contact all three simultaneously, and to inquire whether it might be possible to return to the police station to receive a caution. From experience, that may be possible in circumstances where an individual has made a full and frank admission, and, for example, if the individual was not legally represented at the police station and didn't realise that it might have been possible to ask for a caution or to accept a caution as an alternative. So there doesn't seem to be any hard and fast rule, but from experience, the procedure would appear to be the best way to do it is to contact the court, the Crown Prosecution Service and the police, and to inquire whether a caution might be available.